Buckle up, guys. Today, we're diving straight into chaos as this defendant marches in claiming he can handle the law solo. Judge Fleischer doesn't even flinch. He immediately questions his experience, compares self-representation to performing brain surgery on yourself, and sets the tone for what's about to be a long, painful reality check for this sovereign-citizen-in-training.
Good morning, Mr. Emitum. Do you have a lawyer today?
No, representing myself.
You were charged with unlawful carrying of a weapon. It looks like you also, out of the same charge, picked up a fraud as well. I mean, okay, you can represent yourself. It's your absolute right. I mean, I don't know how smart it is. Have you ever represented yourself before?
Yeah, many times.
And how did that go?
I have many dismissals.
For what kind of cases?
I had a dismissal on unlawful carry before.
And you represented yourself?
Yes.
In this court?
Harris County.
Just found no PC.
Oh, well, I found no probable cause. That's why I got dismissed. You didn't represent yourself.
I was representing myself, but the judge did find no probable cause.
I found, wait, was it me?
No, it wasn't you.
It was.
Well, I don't know. I think it was you.
June 9, 2022.
I found no probable cause.
I think that was you.
You didn't represent yourself for nothing, man. I did it. If you want to represent yourself, you're entitled to do that, right? But yeah, well, I like to tell people it's like brain surgery. When you need brain surgery, when you need heart surgery, are you going to do that on yourself? Because you're not trained, you don't know how to perform open heart surgery. Same thing with the law. You're not trained in it. I mean, I'm assuming that you didn't go to law school, did you? How far did you get in school?
I graduated school. I went to some college.
How far did you get?
2 years I got certificates.
All right, guys. Here the judge officially opens the hearing and lays out the charges. A gun, stolen checks, marijuana, expired tags. This isn't traffic court. This is real criminal exposure. The defendant tries hiding behind private property arguments, but the judge cuts through all of it, confirming probable cause and making it clear the law isn't bending for fantasies.
Are you ready?
Yes, Jim.
Okay. All right. So today is September 11th, 2024. It's approximately 12:25 p.m. We are now in court 5. In front of me, I have Eaton Emitum, case number 2522688. Would you please identify yourself for purpose of the record?
The man eats on Amazon.
Would you please raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? That you're going to tell the truth. That's it. Yes? Okay. State, would you identify?
Petrov on behalf of the state.
Okay. So the reason that we're putting this on the record now is Mr. Emitum has been charged with the offense of unlawful carrying of a weapon. The case is 40 days old. It appears that probable cause has already been found. I don't know if I did probable cause on this, or I don't know if another judge did, because I don't remember Mr. Emitum, and I was out a week. Yeah, lollygagging. So let's just do it for.
On August 2nd, 2024, officers observed a car without a front license plate, changed lanes without a signal, and have expired registration as of March 2023. Upon approaching, officers smelled marijuana. PC search returned 4.17 grams and a loaded Smith & Wesson handgun. Additionally, there was a backpack with 3 checks that did not belong to him. Officer called Kumamoto, who said the checks were stolen from her restaurant on July 8th. When defendant broke the front window, went to the back where the checks were kept in the office, broke the hinge of the back door, and exited.
So as a result, because of that, he was charged with felony fraud on that one,
That's
on the
right.
check. Okay. Yes, he has an open case in the 182nd. Looks like he made a $15,000 bond. With us, I am going to find there's probable cause to go forward.
And now the sovereign citizen logic begins to unravel. The defendant proudly waives some mystery federal property number, insisting it exempts him from state law. The judge just stares at him like he's speaking alien. He reminds him this is criminal court, not YouTube University, and any fantasy loophole will crash the moment it hits real law.
Well, hold on a second. We'll get there. I'll let you say your piece, but do you have a Texas driver license?
I have a US private property number with the FMCSA. What my vehicle was on there, it was sticker tags, everything with my business, the Amazon Estates. That's with the Department of Transportation.
Is that from the state of Texas or from where?
This is federal. This is with the Department of Transportation.
Okay, but you still need a Texas driver license and you need registration and
I did
on
all
a
my
vehicle.
steps with them because it was private property that I had. They said I didn't, if I didn't need to get registration with the state of Texas because I registered it. And they said that would be my voluntary, but since it's private property, I wouldn't have to register it.
Okay. From what I know of the law, you need a Texas driver license to be able to drive.
This is, what jurisdiction is this case being tried on? That's what I'm trying to, because I'm kind of don't know what it's being tried on.
It's
Criminal, civil? Or
criminal, yeah,
both?
right? You're facing jail time, right?
I believe so, but
Weren't you taken to jail?
yeah.
So that wouldn't lead you to believe it's criminal, right?
Yeah, but under common law, or is it military and tribunal? Because also with
Oh, I've
the,
been waiting for something like this for so long. This is so much fun.
I'm just trying to see on what I'm being tried on, because what I was told with the US side, I wouldn't have to register with the state of Texas with the registration or licensing. I do have my own place with that vehicle too as well. So
Do you need a license to drive? A Texas driver license. That's it. You either have one or you don't.
The judge unleashes a masterclass. He calmly explains state authority over roads, licenses, insurance, and even where a plate must be mounted down to the centimeter. The defendant's federal freedom pass theory disintegrates. It's the perfect moment where someone meets the real legal system instead of the one they built on TikTok.
The federal government has regulated to the states through the Constitution that they have allowed the states on their own initiative to create laws regarding driving on highways and byways. So that's why you see every single state has different requirements for licensing, insurance, mode of transportation. The federal government has somewhat to do with it, but by and large, they have delegated to the states that they are their own entity with regard to creating laws in their specific highways. So that's why every single state has a different type of license, different type of insurance. Like the Texas driver license is what, white, versus Arkansas might be yellow or red, or Hawaii might be. So that's every single state has their own laws with regard. In Texas, you have to have a Texas driver license. You also have to have liability insurance as a minimum in the event that you get into an accident. Those are the two main requirements that you need to drive. If you're going to drive a vehicle, it also has to be registered so that they know that you're driving the vehicle and that you own it or have the right to have that, so it's not a stolen vehicle.
I own the vehicle and everything. When I was here the last hearing with the judge, like what he was saying, he said that when it had applied to me, but he was going to see what they were going to say about the other court, about the probable cause of stopping me, because he said registration when it had in the front license plate, when it had applied to me.
It does apply. It applies to everybody. Everybody has to have a back license plate. They also have to have a front license plate. And so much, they also tell you where it has to be on the car. They regulate, you can't put it in the windshield.
State, right?
State,
Yeah.
right. They tell you where it has to be. You can't put it on the windshield. You can't put
This
it.
is where Judge Fleischer delivers the legendary line. The defendant insists on his right to travel, and the judge agrees, telling him to use his feet if he wants to travel. Not a vehicle, not without a license, not under sovereign logic. It's a clean, devastating breakdown of the myth these guys rely on to dodge basic requirements like the rest of society.
And that's it.
Yeah, I stayed to tell him I was traveling. I wasn't arguing with him, but I was traveling. I wasn't making commerce. I used to do medical transportation, so I'm kind of aware with licensing and registration and everything. That's why with my private vehicles, I did that with the US DOT instead of the state. And I didn't know that was
Correct.
And if
You
you're,
have,
they
you
said,
need a license. It doesn't matter whether you're saying you're conveying, whether you're traveling, whether you're, um, you know, driving. It's a privilege. It's not a right, right? There's a big difference between a privilege versus a right. You have the right to
I have
walk.
the right to travel, don't I?
Yeah, and taking your happy-go-lucky feet. You want to travel?
That's-
Take those 2 feet to travel, not in a car.
Just what the 14th Amendment was saying, like, I have the right to travel.
You do. Yes, and you can walk your happy ass from one part to the other part. Not in a car, though.
And I
No.
love it.
From what I did this with the Department of Transportation, they said automobiles were on there, carrier,
Oh.
bicycles.
They're wrong. I'm just telling you now, they're wrong. Whoever told you that, whoever, where you got that, it's complete. Because imagine this, Mr. Emitom, and I've seen this before. Imagine that you get into an accident, right? And you kill a 5-year-old kid. What's going to happen at that point? Whoever owns that car, the other people, they're going to come after you. They're not going to go after they're going to come after you. The first thing they're going to do is, do you have insurance? And if you don't have insurance, they're going to sue you. And then they're going to attach a lien on absolutely everything that you own to satisfy the judgment they get against you. And they will take your house, they will take your car, they will take your bank account, they will attach to where if you ever want to start working and get a paycheck, they're going to garnish all that money.
The judge raises the stakes brutally and realistically. He describes a crash killing of 5-year-old, lawsuits, liens, wage garnishments, and how insurance exists to stop lives from being financially destroyed. The defendant tries to counter with theory. The judge counters with reality. And reality, in this courtroom, hits harder every minute.
You have insurance, liability insurance, so that if you ever get into an accident, you don't mean to do it. You didn't mean to kill the kid. It's not an purposement. It's an accident. And accidents happen. You might be looking at your phone. You're looking at, this pretty girl that's walking across the street, and then boom, you have insurance so that if that happens, the insurance company will pay on your behalf, so you don't have to pay out of your own pocket. And they will even give you a lawyer to represent you on your behalf, because that's what you pay for when you get insurance. If you get into an accident, lawyers usually call you and say, hey man, tell me what happened. Was it your fault? Or was it the other people's fault? Because we want to know who to pay. And that's why for $30 to $40 a month, you get insurance for that very purpose. And I've seen people come here, they have killed someone and they get a $250,000 judgment against them. I've seen it. And God, you'll never dig yourself out of that. So the conveying, the this, that, you need a license. You got to have insurance. And we do it with every single person that comes here.
Can I say for the unlawful carry, the possession of marijuana, the person that was in the vehicle told the officer it was legal hemp that they got from the store. They have receipts and everything in Texas. You can have legal hemp. They got it from the store, even told the officer it was theirs. He pulled me out the car. He didn't ask for any paperwork.
Now you're making the apples and oranges, right? Now we got to test it. Is it weed?
Oh yeah,
Is it him? Understand that takes time, but you also need a lawyer to represent you.
I found my own discovery. I was representing myself pro se.
And you can do that if you want.
Yeah.
But we have to go through a series of questions.
I represented myself plenty of times. I had dismissals here from Harris County.
And for purposes of the record, so Mr. Emitom had a case with me here. It was May.
The judge drags him back into history, reminds him of his previous gun case, then drops the Abraham Lincoln quote about self-representation, making you both the fool and the idiot. It's the judge's subtle way of warning him that ego won't save him from a possible year in jail. But the defendant still insists he knows best.
It was actually June 7th of 2022. He was charged with another gun case. And that was with Victoriano. God, that was a great DA too. And I found no probable cause in that case, right? So you didn't represent yourself in that case. I found no probable cause and they dismissed it. They didn't have to dismiss it, but they did dismiss it. So other than that case, have you ever represented yourself?
Yeah, many times. Dismissals all through here from Harris County. Traffic violations.
You're welcome to do it. and, you know, who's one of the worst, who's one of the best presidents that in history that you can think about right now?
Wonderful to me right now.
You can't think of one good president that we've ever had?
I don't know any.
Abraham Lincoln, he wasn't good?
I never met him. I don't know about him at that time.
Abraham Lincoln said something. He goes, you know what? He who represents himself has a fool for a client, meaning that when you represent yourself, there is an inherent conflict and there's an inherent bias, and you may not be able to see things objectively, meaning that you have your heart, you've got your soul into this case. So you may not be able to see from an outside position if they're saying something that makes sense. You're absolutely entitled to represent yourself. And if you want to do that, you're more than welcome to it. And I have no problem with you doing it. You need to understand, though, if you represent yourself, you can't come at a later day and say, you know what? I had ineffective assistance of counsel. My lawyer sucked. Well, you represented yourself. You now can't complain about that. You know, if you go to trial and you lose and I end up putting your butt in jail for a year, you can't complain. You're stuck like Chuck for a whole year because that's what you're facing. You're facing a year in jail and you got a bunch of other documents too that, you know, so.
The judge now checks competence, name, age, education, literacy, mental health, law knowledge. The defendant admits he barely knows the statutes. The judge warns he'll be held to attorney-level standards with zero hand-holding. Watching the defendant nod confidently while knowing nothing is the calm before the storm of self-inflicted disaster.
My discovery from that last month that I filed.
Well, let's do the question. So, what is your full name?
Eton Cheeseroke Amaton.
Okay. How old are you?
I'm 34.
Where were you born?
In America.
Were you born here in Houston? Were you born in?
From Texas.
Okay. You read and write English, right?
Yes.
Okay. Do you have any learning disabilities or communication handicaps? Have you ever been declared mentally incompetent or treated for any mental health disorder? Okay. You said last time I asked you about your educational background, you graduated from high school.
Graduated high school, some college.
How far did you get in college?
About 2.5 years.
Did you do any legal courses whatsoever?
Left that and I started doing medical transportation. I was taking classes for paramedics. I was just doing my basics. I was doing my basics.
Studying in college.
I was just doing my basics. I ain't getting into it. Yeah.
Yeah, I mean, that makes sense. And when you're beginning, that's all you do anyways, right? Do you have any legal training, education, or experience?
I've had experience with dealing with the court being charged before.
And any other legal? Do you know about the Code of Criminal Procedure?
Yeah, I'm familiar.
Do you know about the Texas Penal Code?
I'm familiar, but I'm not too familiar with a lot of statutes and codes.
Were you here for our earlier trial?
No, I went up.
I know you went to the felony court, but we were in trial earlier. Did you see what happened in trial earlier?
I had like a glimpse of it walking.
Okay. What I'm trying to say is that the lawyers on both sides had to introduce evidence. There's a specific procedure that you have to follow to have evidence admitted. It's detailed in the codes. You have to know that because once you represent yourself, I'm going to treat you as if you were a lawyer. I will hold you to the same
Here
standard.
the judge dismantles the biggest misconception in effective assistance appeals. He explains that most defendants blame lawyers, but if you're your own lawyer, you can't blame anyone. If you mess up, you're stuck. No appeal, no redo. The judge is practically begging him to accept counsel, but ego keeps steering the ship.
Do you understand that? What that means is that you cannot appeal this thing. If you're found guilty and you go to jail, you know, a lot of lawyers or a lot of defendants like to claim, sorry guys, I'll be 2 minutes. A lot of lawyers, a lot of defendants like to blame their lawyers for screwing up. And they say, hey man, my lawyer messed up. I can tell you, like, that's the number one thing that defendants complain about. And probably, I don't know this for sure, but I would suspect probably the number one reason why cases are overturned because of ineffective assistance of counsel, meaning that a lawyer, for one reason or other, messed up so bad that their cases have to be redone. You cannot complain about that at a later time.
I've seen that many times. That's why I'm representing myself.
But you can't, if you mess up, you cannot appeal this thing. Do you understand? Once, and if you are found guilty, that's it. Do you understand? You also have to comply with the same appellate procedures if you lose, meaning that if you want to appeal for one reason or the other, you have to understand the guidelines and the timing, and you have to comply with those rules as well. Do you understand?
Mm-hmm.
You will not be granted any special consideration because of your lack of formal training. Do you understand this? You may fail to properly raise points of error in the trial record if we go to trial. Meaning that if we go to trial and you object to something, because that's you hear that a lot, right? I object. This shouldn't be in there. You have to object properly. You can't just say object. There has to be more to it. You have to state the reason for the objection. It has to be a legal reason. You can't just say, I object, and expect
This
me
part is where the tone hardens. The judge offers a lawyer anytime, but also slams down strict bond rules, no weapons, no new charges, and no driving, period. Then he delivers the infamous warning that he'll set a bond so high the defendant's head will spontaneously combust, another sovereign illusion shattered by raw courtroom authority.
Is this voluntarily, knowingly, and intelligently made? No one's forcing you to do this. Okay. Knowing all this, are you sure that you still want to represent yourself? I got to tell you, I think that you look like a great guy. You look like you're upstanding. I have no problems that you represent yourself. Understand that you need to be careful what you tell them, though. Everything that you say, even if you think you're hurting yourself by admitting one thing or the other, you could be hindering your case, meaning hurting your case, even if you think you're helping yourself. Do you understand? I'll make you a deal. If at any time you want a lawyer, all you got to do is ask and I'll give you one. Really. If you ever feel like you're under the gun, that you feel like someone's taking advantage of you, I'm happy to give you a lawyer at any time. I want you to understand now, as a condition of your bond, though, I'm ordering you not to drive until you have a Texas driver license and a liability insurance. I'm ordering you not to drive. And I'm going to have you sign with me today an affidavit promising me you're not going to drive. If I find that you drive, I'm going to put you in jail. Do you understand?
Travel, I have personals.
Okay. You are not allowed to get into the driver's seat of a car and drive, convey, travel, however you want to term it. You cannot do that. And if I find that you do that, I'm going to put you in jail. And I'm going to make your bond so high, your head's going to spontaneously combust. Do you understand?
That way from my rights to anything? Or
No, but I'm telling you that you can't drive, convey, get into the driver's seat of a car. If you do, you're going to go to jail because I will revoke your bond. The only conditions I'm putting on you now are 3. No weapons, no picking up new cases, and don't get into the driver's seat of a car and drive, convey, travel. Are there any other adjectives that you can think of?
I'm sure there are, but
I guess I'll put et cetera so that it tries to cover any type of.
Here the judge and prosecutor tag team his bizarre discovery motion. They mock his demand for every witness in Harris County and reject his kitchen sink approach. It's a moment where sovereign theory meets legal procedure and falls apart instantly. The judge grants only what's reasonable and shuts down the rest with surgical precision.
Your Honor, at this time, the state wouldn't even be able to comply with this order because it's asking for an immediate order of discovery. It sounds like spontaneously I need to give
Well, other than
the
that,
opposing party.
I mean, and is he asked?
And it's not, the language is not aligned with criminal procedure or penal code. But beyond that, the only 2 pieces that are requested that are reasonable that I can produce with a timeline are 1 and 7.
So, Mr. Emitom, understand that you will get discovery, but sometimes it takes time. It's not immediate. It takes time to build a case, to get videos, 911 calls, reports from officers. It takes time. It's not immediate. In your motion, I guess it says he wants it immediate.
Immediate order
There's
of
just no way. We can't.
an inspection. Yeah.
But we will get it to you as he gets it, he will give it to you. I can grant you the order. I will take off the immediate provision, but I can grant you everything that you want. I'll give you their case file. I can give it to you when they get it.
Yes, but Judge, this discovery order is requesting things outside of the scope of discovery.
Well, I'm not going to give him the kitchen sink. I mean, like what?
Everything else. I mean, so 1 and 7 are aligned. 1 is requesting any documents, papers, books, accounts, letters, photographs, videos, which are body cam, objects or tangible things not privileged which constitute or contain evidence. Of course, I'm going to hand that over.
Okay.
2, any and all names of any witnesses, the Harris County Superior Court, State of Texas.
I mean, that's
County of
so
Harris,
broad, Mr.
and
Emmett.
or any political.
I mean, you want every
subdivisions.
single witness in Harris County? That's what that's asking for.
You have to properly represent myself for the case.
That's 4.2 million people. Really? Really?
So that doesn't,
I mean, I'm not going to grant that. That's silly.
it's too
You want-
broad, it doesn't go into the scope of
Imagine
discovery.
any and all names of any witness for the Harris County Superior Court, State of Texas, County of Harris, or any political subdivision thereof may have. That's so broad that to even try to comply with that would take years. That's
Now the judge calls out the UCC nonsense directly. He tells him common law doesn't apply, everything is statutory, and if he doesn't even know that, he's doomed representing himself. The prosecutor also highlights that none of the language is legally valid. This is where the sovereign citizen playbook officially collapses on the record.
okay.
So, Your Honor, I will not be agreeing
Doesn't
to
apply
that.
here. There's no I mean, you're saying a true and complete original and or certified copy of the alleged is not even spelled correctly, contract with wet ink signatures between the petitioner and the Harris County Superior Court. I mean,
So I'm opposed to that.
what contract?
Contract complaint, whatever. I know this is statutory and it's not going over common law, so I'm not familiar with the statutes like I explained before.
Well, you're a lawyer now. You're going to have to familiar yourself with it.
You're trying me on statutes. I want to be tried on common law.
You're going to have to do it. I'm not sure. There's no common law here. It's everything's done by statute. There's no common law here. It's all done by statute. And since you're the lawyer, you need to know that.
I recognize the steps of the statutory steps. That's why I don't recognize
So
being tried in
let
jurisdiction.
me ask you this. How on earth are you going to represent yourself if you don't even know that?
Once I get everything I need in my discovery,
He's going to give you body cams. He's going to give you 911 call. He's going to give you witness lists. And that's it. Right? Is there anything else that would be in here?
going down the list.
I would, so there may be dash cam I need to check. So I haven't gotten the body cam or dash cam yet. I need to check what all of this.
But Mr. Emmett Tom, I mean, let's get real. If you're having problems with things of this very elementary nature, how are you going to represent yourself? I'm happy to give you a lawyer. But some things are just, I mean, there's no,
We must conclude this hearing.
come on, don't be Helen Keller. Come on. And I'm trying to protect all of Harris County.
I don't know the
You're protecting you. I'm protecting all the 4.2 million people here. That's what I'm doing. Because if you get into an accident, I know that you're not going to be out a dime out of your pocket. But all those other people, they're going to be out a crap load of money. And I'm going to do everything in my power to protect every single person of Harris County. And I don't care if I offend you. I don't care if I make you mad. I don't care if your sensibilities are upset. Don't care. I don't. All I want is every person protected. And that's it. And I'm doing what the law requires. I'm not asking you to do anything that's not outside the law. And you, acting as a lawyer, should be able to look it up and see, because it's all in the transportation code. So you can sign it. If you don't, I'll have you meet with Stephen. That's it.
I just want my rights reserved.
They're reserved.
I'm waiving my rights to the court.
No.
Signing that's waiving my rights. It's a contract. It's me.
What right are you waiving?
My right to travel. That's infringing my right to travel with the Constitution.
No,
I wanna protect the
no.
rights of
Take the
14th.
Dodge Patas.
14th, I don't know what that means.
Happy trails. Use your feet. You can travel with your feet.
I can, but I live in Austin. I don't live out here in Houston.
Take a bus. Take an Uber. But I want to make sure if you're caught driving, I'm going to put you in jail, and I'm going to make your bond so high you will spontaneously combust, because I want you to understand that I mean business and I'm protecting every single person I can. And that's it.
The court forcing me to sign this right now.
No,
Threaten me with jail or arrest if I don't sign this. Right
correct.
now.
That is correct.
I'm in
That's correct.
imprisonment if I don't sign this. This is on the record.
It's on a record. I have a reporter right here. And it's
Final
on video.
showdown is pure intensity. The judge demands a signed promise not to drive. The defendant claims it violates his right to travel, and the judge fires back: walk, bus, Uber, anything except a car. He repeats the combusting bond warning and makes it clear drive again and jail is guaranteed. It's the ultimate clash between fantasy and law. Thanks for watching. Don't forget to like the video, subscribe to the channel, and we'll see you in the next video.